Hello and welcome to the lecture of International Business Environment. In this lecture, we will going to have a discussion on the settlement of international trade dispute, Unit 16 of Block 4. Topics to be covered are alternative dispute resolutions, major issues in settlement of international trade dispute, overview of Indian Arbitration and Conciliation Act 1996. Yes, as we had a discussion in the previous session about the arbitration and conciliations, and we had a discussion about the litigations also, that they are the one of a method which are used for settling the dispute in the international business. So alternative dispute resolution is again one of a method to resolve the disputes arises in the international business. अगर हम ADR की बात करते हैं तो ADR एक मेथोडोलॉजी है, एक मेथड है जिसके थ्रू हम लोग इंटरनेशनल ट्रेड प्रैक्टिसेस को डिस्प्यूट फ्री और कंफ्लिक्ट फ्री बना सकते हैं. इट्स अ टेक्निक विच इज यूज्ड. ये एक टेक्निक है जो कि यूज की जाती है टू सॉल्व ऑल द डिस्प्यूट अराइजेस इन द इंटरनेशनल पार्टीज. So dispute resolution process and techniques that fall outside the government judication process. तो ये एक वो टेक्निक है जो गवर्नमेंटल जुडिकल प्रोसेस से बाहर आती है. So in that case, yes, ये 4 तरीके से की जा सकती है. This process or this settlement was done in the 4 different methods. That is, the person can have a straight conciliation with them, or they have a meditations, or they have the mutual negotiations for that, and the collective laws was used in that case. ये methodologies traditionally used होती हैं to bringing out a proper settlement in the two parties. So this technique is probably working for to bringing out right practices to solving. This is one of a very informal, we can say that's a kind of an informal method as it's out from all the government legislation. If we take the example of a conciliation, conciliation is basically of settling out a dispute with the help of a third party. And yes, at the same time, we can say that both the parties submit their statement to the third party, and third party finally come up with the certain kind of solutions or that. If we talk about meditation, meditation is again that kind of a technique, or we can say that it's an informal kind of a technique was used when the mediator, as it's a neutral party, performed to bringing out the settlement in the disputes. And yes, at the same time, mutual negotiation is when both the parties agreed and mutually comes into a one decision. So that's come into the mutual agreement. So these are all those techniques which basically used in ARD. AD are basically a very traditional, and somewhat it's basically depends on country and the culture of that particular country. And they basically justify, they use that kind of a law to justify the main concept of that factor through which the dispute arises. So the ADR is basically, yes, used to bringing out the lower down the practices, or we can say that lower down the caseload of the courts. Yes, at the same time, it is used to signifies the very easily settlement for those party who don't want to be through very legalized procedure, जो legal procedures को avoid करना चाहते हैं, they probably can use ADRs. So it is basically designed to have a very quick, have a very fast and informal, non-traditional method. So now this is what basically used in the ADR. Now ADR is basically concluded or include all those informals and formals, meditatives and tribunals of that particular country. So the very classical formal tribunals form of ADR are arbitration. Arbitration is a very formal tribunals जो की responsibility लेती है इनकी पूरे एक लीगल तरीके से उस रिजॉल्व करने की डिस्प्यूट को और उसकी सारी मेथोडोलॉजीज को एक रिटन डॉक्यूमेंटेशंस की तरह परफॉर्म करते हैं. If we talk about the classical formal meditative process, so it is what basically defined as a court was appointed for having the right meditations, appeals and meditators practices. So in that case, अगर हम लोग बहुत ज़्यादा formal meditatives में जाते हैं, so उस केस में एक legal person appoint किया जाता है to resolve that disputes. So one of the major difference between that formal and informal processes, again, yes, there are the major process to resolve that dispute. In these major processes, the arbitration, litigations, and yes, the other alternative dispute resolutions was available for all those party जो कि अपने disputes को resolve करवाना चाहते हैं. But in that case, there is a major difference between the informal and formal. अगर हम informal and formals की बात करते तो सबसे पहला point is the court procedures. They had a chance to avoid that court procedural practices because it's again inviting the different kinds of laws in that term. So that comes into the court procedure is the first difference. Second, the lack of a formal structure. Yes, as to having a very long court procedures, you can avoid the formal structures also, the applying for the application and then come into the procedures. उन सब practices को भी again minimize करने के लिए there was a formal structure and the formal practices of resolving that disputes, and the other have an informal practices of settling by their own or by their mutual understanding. So that minimize these things. So these are the two major factors and through which there is a difference between formal and informal procedures. Now, what are those major issues जब हम एक settlement की बात करते हैं, international trade settlement की, तो कौन से ऐसे major factors हैं जो कि consider किए जाते हैं? सबसे पहले तो applicable substantive laws, that means कि कौन से laws basically follows हो रहे हैं, क्या issue है, what are those factors to be considered in it, that is the first thing. Second issue जो कि consider किया जाता है is the forum, that is the गवर्नमेंट, दैट इज किसके पास रिस्पॉन्सिबिलिटी है, कौन सा फॉरम है जहां पर वो अप्लाई किया जाएगा. देन वेन्यू ऑफ आर्बिट्रेशन, दैट इज ब्रिंगिंग आउट द प्लेस इन विच दैट सेटलमेंट वाज अकर्ड. देन एप्लीकेबल प्रोसीजरल लॉ, द होल प्रोसीजर ऑफ सेटलिंग दैट डिस्प्यूट. रिकॉग्नाइजेशन एंड रीइंफोर्समेंट ऑफ फॉरेन जजमेंट्स. yes, at the same time जब किसी भी तरीके की जजमेंट है, so किस गवर्नमेंट से अप्रूवल्स लेनी है, और we need a recognition and enforcement from them. Another is law for enforcement of foreign awards in India. What are those laws which are enforcing these practices to bringing out into the judgment? Then enforcement of the Indian awards कि अब किस तरह से उस judgment में rewards जो हैं वो दिए जाएंगे, that is was considered. So ये सब major issues होते हैं जो कि एक settlement के अंदर consider किए जाते हैं. If we talk about the Indian Arbitration and Conciliation Act 1996, this act is what basically giving us the idea about the arbitration and conciliation. If we talk about this act, so arbitration is considered as in a process of a dispute resolution in which the one neutral third party was introduced to have a right decisions of their parties. उन parties के disputes को सुनने के लिए एक third party को appoint किया जाता है in arbitration. What are those major objectives of arbitration? The very first is the comprehensively cover both international and domestic arbitration and conciliation, that is covering all the factors of arbitration and conciliation, give out the right provisions for that the person may have a sense of having a fair, efficient and capable judgments on that, provide the arbitrary tribunal good reason for rewarding that thing. अगर आप कुछ reward कर रहे हो तो there must be a good reason for that. At the same time ensure that it is within the limit of the judici, that means जो भी decision या जो भी reward दिया जाएगा वो act हो proper reasoning के साथ law के अंदर होगा. So that comes into the objective. And yes, the next is to minimize the supervisory role of the court. It is again one of a very important role for all those the mechanisms or method was used to minimizing the effect, that is to minimize the supervisory role of a court. Another is have a permit of using all that meditation, counseling and other procedural factors. बाकी सारे procedural factors को भी use किया जाए, इसकी भी permit एक objective arbitration से आती है. Then to provide the final reward is again the objective of arbitration, and it is what the obligations of a party जो कि उन्हें perform करनी होती है. Both the parties, now whatever the reward was come, दोनों ही parties को perform करना पड़ता है, उसे मानना पड़ता है. And then to provide the settlement to reach by the parties. Bringing out a right settlement, एक सही settlement होनी चाहिए, and it is what agreed by both the parties. Now the arbitration agreement, this is what basically talks about the agreement which have arbitration clauses and arbitration practices. So it's an agreement, and yes, it must be in the written form. Another is, it is basically used in the form of an exchanges of a letter, and yes, it is considered as a separate comprehensive independent agreement. ये एक independent agreement होता है. This is agreement done by both the party. It could be written, it shall be written probably, and yes, at the same time, it is basically used as to have a right contractual practices between the parties related to their arbitrations. If we talk about the number of arbitrator was used in the particular practice, so the parties are free to decide the number of arbitrators. They can have a full right to decide, but it shall not be in an even number. So if the parties fail, the arbitrary tribunal shall consist of the sole arbitrator. So in that case, there is a one condition, that is the arbitrator can't be in the even number, but yes, parties are free to have decide the number of the arbitrators. How we are going to appoint the arbitrator? The very first is, the person must be belongs to the one nationality, and yes, at the same time, they have a right, and they were appointed from the government to have a right practices on that arbitration. And yes, the Chief Justice should consider all that qualifications, independent and impartial qualities of arbitrators. Now, conciliation. Again, conciliation is what the adjustment and settlement of that particular dispute between the two parties. Now, they are basically, party wants to apply for the conciliation. They basically invites the third party to enter into the dispute and try to resolve that dispute. So, procedure concerns only when there is a reply received within 30 days of the rejections of invitation. If there was a rejection, then yes, the conciliation can't be considered, but there is a time of 30 days of the agreement of that particular conciliation. On the rejection or demanded rejection, first party must be re-informed about that other rejection. Now, if we talk about conciliation, so conciliation is what basically having a parties of 2 or 3. So the one is by the mutual agreement of a parties, 2, 1 each by each party, that is एक तो अपॉइंट होगा जब दोनों ही पार्टीज म्यूचुअली एक काउंसलर को अपॉइंट कर रहे हैं, 2 तब जब दोनों ही पार्टीज अपने काउंसलर्स को ले रहे हैं, थर्ड is 3 is when then 1 by each party and third by the mutual agreement. So that is the way the number of conciliators are used. If we talk about the relevant provisions at the glance, so conciliators not bounded for the Code of Civil Procedures in 1908, and they are basically, they have an objective to resolve the issue with the fair means and have a right and fair practices, come up with the good manners, bringing out right administrative assistance, and yes, bring out the judgment on the required limit and required time also. So settlement agreement, that outcome of the conciliation is where it appears to be the conciliator that exists the elements of having a formal terms. There should be a certain terms that have a proper observation regarding the content, that is issue. Whatever the issue, have the right observation, bringing out into the right practices, submit them, and then yes, approval that come into the right judgment is the one of the form. So reformulate the agreement, then after reaching to an agreement, the formal settlement should be drawn. The formal practice or signed by both the parties must be there. So that's comes into settlement agreement. So settlement agreement basically is the final binding. We can say that then both the parties have now obligations to perform after resolving their issues. So this settlement agreement must be signed by both the party, must be written, and yes, declared by party, yes, they are agree with that procedure. So that comes into the settlement agreement. So in this session, now we will basically have a glance about that what exactly Indian Act perform in the arbitration and conciliation, how many number of arbitrator and conciliator we required, what is ADR, and what are those necessary factors in all these settlement disputes. So this is all about for today's session. Thank you so much. IGNOU MOOCs.